So we're going to move into this next piece over lunch, and we're going to talk about our victim services, but really our victim witness coordinators. And honestly, as a police officer, I feel really strongly this is such an important piece that we have people in these positions, because the criminal justice system as a whole does not take care of victims very well. They're often forgotten, and they're not really taken care of through this process. And this is something that these folks do, and they do a really good job at, but oftentimes it's misunderstood, or people aren't even aware it exists. So I'm really excited to have them share a little bit about what they do so people can better understand that, to make sure that people understand what's available to them as far as resources and support through the criminal justice system.
All right, so I'm Rachel Murphy. I'm the Victim Witness Coordinator with the Garden City Police Department.
And I'm Amy Snyder, Victim Witness Coordinator with the Prosecutor's Office, the Ada County Prosecutor's Office. And we also have Victim Witness Coordinators in the Boise Police Department, as well as the Ada County Sheriff's Office and the Meridian Police Department.
Yeah, so in total here in Ada County, we have 23 Victim Witness Coordinators that work for all of these agencies that you see.
So some of the primary things that we do is our basic role is really in the very beginning is to make initial contact with that victim and kind of answer any immediate questions, because they don't know. It's like this crime just happened and oh my gosh, now what? And so we really want to be there for them to support them as this process rolls around. Victims do have the right to know what those court dates are going to be. As well as a lot of times, and I think it's really good when victims are able to meet with the prosecutor on the prosecutorial piece of things, because it takes a lot of anxiety away. Personally, I think the word prosecutor is a bit intimidating, but as soon as they're coming in and visiting with us, they realize, oh, this is just a person and they're doing their job, they're doing what they're supposed to, and they want to meet me and they want my input. So we do a lot of that. There are people that don't want to have anything to do with us, which is okay. I mean, sometimes they come back around. And then, let me see here. And then they do ask questions of what's going to happen. Is he going to go away? Is he or she? How long? What does that look like? And so some of that we can talk about that they, prosecutors are looking at what kind of criminal record a person has, if this is the, first time versus the 10th time. And so we do address those questions, and we give them a lot of information in the beginning, and it's like, just call me if you have any questions. Call me if somebody's chipping in your ear, because somebody else's experience will be different than theirs, and we don't hide the ball. I'm just going to tell you this is what I know, and if I don't know the answer, I'm going to get the answer for you. And then one of the things under Victim Rights Amendment, we'll talk about a little bit later, is that the victims get to know what the prosecutor is going to be asking for as a sentence. And so that's why that meeting is important, because you have some people that, I don't care, just do whatever you need to, or no, this never happened, especially like in domestic, they'll minimize and such, which is fine. That still helps the prosecutor figure out what should we look at doing to resolve this case. It is the state's case, and we talk about that to victims, is that it's something, it's the state against the defendant. It's not you pressing the charges. And so you can put all the prosecutor's the bad guy if you need to, because sometimes that takes pressure off the victim. I went in there and I told them I wanted this dismissed, and they're not dismissing it. And that's true. We get lots of that. but
Right.
We say, sorry, it's the state's case. We go to court if they're wanting to go to court. Sometimes you have a victim that will say, I don't want to go, but can you go? And I go because they want to know, and sometimes I'm able to pick up some tidbit information. The one that if I'm in a double court, in another courtroom, and a victim says, well, did you go? What did they look like? Were they crying? Were they upset? And I'm like, oh my gosh, I got to go make sure I know the little details. And sometimes you just say, well, I wasn't able to make it. You just tell them the truth the whole time. We do provide resources and referrals if somebody's got some mental health issues. Anytime there's FACES and WCA is the ones that we use a lot, because they have a lot of different types of services that they can provide. And then when it comes to the jury trial type of things, we also do help witnesses get to where they need to be sometimes, because the prosecutor literally is focused on doing their job at the jury trial, is to prove the person did the crime. So
Yeah. So let's talk about call-outs. Call-outs are sometimes the first time a victim witness coordinator will meet with a victim. So each law enforcement agency that we referenced in the beginning has a victim witness coordinator that is on call 24/7. So sometimes I get called out during the day, sometimes that looks like 2 in the morning. It's really when law enforcement sees that a victim witness coordinator is needed out on that specific call. So when we go out, we could be going out to a hospital, we could be going to Faces of Hope for a sexual assault examination, we could be going to that residence. It really just depends where we're needed. But when we get there, we assess immediate safety risks and concerns. And then we develop a safety plan for that victim. That could look like a lot of different things. If the victim needs a safe location to go that night, say the suspect was not arrested, we don't know where the suspect is at that time, and there is a safety concern, we will get a safe, confidential location for that victim that evening. And so really when we're going out on these calls, it's really assessing what does that victim need immediately tonight. We will do more long-term solutions, but at that night, we're really seeing what is immediate and what can we do now. We also explain the role of victim witness coordinator, especially because most people don't know what victim witness coordinators are. When we meet with victims, I would say 80 to 90% of the time they've never met a victim witness coordinator before. So I explain my role, and that's really twofold. It's to help during the court process, and then it's also any resources that victim needs throughout that time. So the court process, and we'll go over that in a minute, it can be complex, it can be confusing, and that's really our job, is to answer any questions that the victims may have and make sure that they know where we're at in that court process. And then resources, we'll touch upon that later on, but that evening we'll discuss what kind of resources might they need. And so really we get the contact information from the victim that night. We'll either do a phone call the next day with the resources, or we'll email them or mail out resources. But we really do focus on making sure that we answer any questions that they have. A lot of resources that come up during that time is, where can I go get counseling? Where can I go get some legal help for some civil issues? We have this criminal case right now, but I have a lot of civil questions. Where can I go for that? So we really do discuss with them available resources that are in our community. And I always think here in Ada County, we're really lucky to have the nonprofit agencies that we do have. So the court process and resources we really discuss. I don't want to overwhelm the victim too much during that time because there's already so much information being thrown at them. So that's why we follow up immediately the next day as well to touch base with them and then discuss what's going to happen. I will say too, during call-outs, if the suspect has been arrested, the court process will start the next business day. So say suspect is arrested Friday evening, it won't be until Monday that court process starts. So we'll discuss, what do you expect that day? What is the court going to look like? And answer those questions at that time. If the suspect wasn't arrested, what does that look like? What is that process going to be? So we'll answer those questions as well for them so that they know what to expect. And I think that's really important. They have all these questions, especially if it's over the weekend. We don't want those victims to stress, what's gonna happen Monday morning? What am I supposed to be doing? What are my options? So that's what we do during call-outs, is we try and answer as many questions as we can. If they have specific questions for the prosecutor, we'll let them know that we'll be in contact with them. And once a prosecutor is assigned, we'll start that process of getting those meetings or those phone calls available.
So this is kind of a sketch as to how the process goes, more so on felony type of cases. So the crime happens, the police are called, then a report is written, and then it comes down to the prosecutor's office, and then they have a screening team, and so they're looking at what just happened and do we need to look at filing charges against this person? And so then at that time, then after that, then there's the first appearance. And on felony cases, it would be typically a video arraignment, and like in domestic violence cases, if somebody got hurt the night before, the next, like she was talking about, the next business day would be that video arraignment at 1:30. And so we're giving victims a call in domestic violence cases right in the very beginning of the morning, when we get a police report that somebody's going to be arraigned at 1:30, we're calling them, we're setting up to be able to meet with them about 11 o'clock if they want to. If they want to meet with the prosecutor, they don't have to. The no contact order is typically an issue for a lot of people, so we can try to address those things. And then now with the way WebEx does it, we give them a link to that video arraignment so they can actually watch. Sometimes the judges will also allow victims to address the no contact order as to what they would like to see. And then they can also file a motion to lift or modify that no contact order down the road. But we're giving them all that information. And then at 11 o'clock, we call, because of COVID, it's changed things a little bit. So a lot of times we'll conference call with a prosecutor. So then the prosecutor's given them, this is kind of the next things that happen. But if somebody needs an exam or anything like that, then they typically go to FACES, and we're meeting them at 11 to try to make it a one-stop shop kind of thing, so they can do their exam, they can meet with the prosecutor, and then you know, the next point would be that video arraignment at 1:30, and then after that, at that video arraignment, a person is told what they're being charged with. A bond amount is set. No contactors will get put in place. They also happen on, you know, rape charges or injury to child, and then domestic. So any time stalking cases, we'll look at putting in a no contact order there. And then once we get the next court date, which is usually about 2 weeks out, and that would be the next phase would be the preliminary hearing, which a preliminary hearing is a probable cause hearing. It's basically the state has to show that this person probably more than not did this crime. And so it's a real low standard. It's not like a jury trial where it's beyond a reasonable doubt. And so sometimes defendants do want their preliminary hearing, and so we have those, and then the victim would have to come testify. And so we're trying to prep them within that 2 weeks as to meeting the prosecutor, saying this is what the state would like to see happen. The defendant could say, no, I don't want to, I want my hearing, and then we have to have that victim. Or they can waive their hearing, or it's set over sometimes. Another way for a probable cause hearing is the grand jury. We don't use that a lot. It's more on sexual assault type of cases, and especially sex abuse cases on kids. And what a grand jury is, it's about 12 to 15 people. The grand jury sits on that jury for about 6 months, I think, unless they've changed it. But they're the ones that decide about that probable cause. And so the only people that are in that grand jury is the prosecutor, the grand jurors, and the victim or witnesses. There is no judge, and there is no defendant or no defense attorney. And so that's one way, but that doesn't happen very often, but that's another probable cause type of hearing. And then once we get through that phase, then they go to, or bound over is what we call it, the case shows that there's enough there for a felony. Then it would go to a district judge or felony type of judge, and then at that time the defendant is told what he's being charged with, and then at that time really is the first time that he or she can plead guilty or not guilty. They can't at the preliminary hearing stage. And so then if we get a person says, yeah, okay, I'm pleading guilty, then it would go down that road, or it's going to go down the jury trial road. And then if we find guilt at a jury trial, then the pre-sentence investigation piece happens, and that's where there's an investigator person that gets as much information about a defendant as possible. They interview the person, they get all the police reports, if there's any evaluations that are done, like mental health, drug and alcohol, domestic violence, all of that information goes into this report. And so a sentencing usually is about 6 to 8 weeks out, so that person can gather all that information. They also call the victim, and a victim can make their victim impact statement through them. And basically a victim impact statement is how the crime has affected them and what concerns that they might have. So it's pretty broad. And so sometimes, like in domestic type of cases, that's an opportunity for them to talk about a whole history and not just the crime at hand. And then we have the sentencing, which, let me back up. The pre-sentence investigation report is a confidential document. Only the attorneys, the defendant, the judge, and the victim get to read it. And then it's sealed once the case is completed. And so that all of that information does help a judge figure out, how am I going to sentence this person? And then we make it to the sentencing, and a victim again has another opportunity to make a victim impact statement if they choose to. Sometimes people just speak from their heart, they write something up, or they don't want to do one. It's totally up to them, and we help them write that if they want to. It really is based on how they feel. And so sometimes they want you to review it, or sometimes I've seen them, can the prosecutor just read it? And they're willing to do that. So
Right. So as Amy just went over all of this, there's a lot happening. There's a lot of hearings, and that's not even all of them sometimes. Sometimes there's motion hearings. Sometimes the defendant wants to motion to reduce bond if he's still in custody or she's in custody. Sometimes the victim would like to motion to modify and or terminate the no contact order. So our role really is to make sure they know what's happening next, answer any questions that we can, and to really just make sure they're informed of all their options as victims. A lot of victims don't even know that they have rights going throughout this process. So we want to make sure that they're aware of all their rights, make sure that they're aware of where they're at in the process, and then really answer any questions, because it can be pretty confusing.
So there is a victim rights amendment that we really make sure happens, and the gist of it is the victim has every right to be at every hearing. And like at a preliminary hearing, I'll give an example, or even at a jury trial, witnesses can't be in through the whole thing. Witnesses are only going to testify and come out. In regards to a victim, they have a right to be at every hearing, so they can sit in and watch the whole thing under the Victim Rights Amendment. A lot of times, we have to tell them, you cannot make any, you have to have a poker face, you cannot make any emotion and all that, especially like during a jury trial. And that can be real difficult. And they can have people to come to support them as long as they weren't a part of the crime at hand. So that's helpful. Sometimes they don't want to, and sometimes they do. Like at a preliminary hearing, though, a lot of times I'll see that they want to stay, because then they can hear more about the crime as to what happened, because they don't get to read the police report until the case has all been sentenced. They only know their piece, and we can't just give them a copy of it. And it's just because we got to keep the integrity of the case, and you need to testify as to what you know, not what you've heard or read. The other thing is that, like we've kind of talked about, that they can go to every hearing with a victim witness coordinator if they want to. Sometimes you'll have some, no, I don't want to go. And then you have the prosecutor texting you saying, such and such is here. And you're like, oh, I didn't know. So we are able at least to go right up to help out in that part of things. And we mentioned before that they do get to know what that plea agreement is going to be prior to it being given to defense counsel. So that part is, I think, good too. And then, of course, timely. We would like to see it quicker, but we do hope to move, the cases along as fast as we possibly can. But a lot of it is dependent upon the defendant, and the ball is in their court. And if there's these motions that need to be heard, or for, if somebody has to get checked out for mental health, that might delay things a little bit, to make sure that the defendant is understands what's going on in the courtroom. So sometimes that can delay
Especially
things.
with COVID right now.
Yeah, COVID is a whole nother.
Jury trials being suspended and then starting up again and then suspending, that can delay it quite a bit, unfortunately.
It does. And the one nice thing about Vine, I don't know if any of you are familiar with Vine, but it's a victim notification system. So when a defendant gets into the jail, law enforcement will hook the victim's information into this system. And so when somebody does bond out or is released, the victim will get notified that that person is about to be released, probably within the next couple of hours. And so if they escape, victims have the right to know that they're escaping or have. And so that part's good too. And the other thing is, when it comes to defense, we tell victims it's completely up to you who you talk to, that they don't even have to talk to us if they don't want to. But sometimes I feel that when people are in authority positions, people feel like, oh, okay, I got to call them back, or, oh, I have to talk to them. I'm like, it's totally up to you. You can talk to them, or you don't have to. Or you don't have to talk to us.
Which happens.
Which happens.
It's completely fine.
So these are the cases that we primarily are assigned to, anywhere from a homicide all the way to a malicious injury to property type of case. So, you know, it's rape, an aggravated DUI. The malicious injury to property, sometimes we are and sometimes we aren't. It kind of, if there's a domestic thread that's through that malicious injury to property, we probably would be. If it's a victim that's calling the prosecutor every other day or 3 times a day, we might get, can you call them, can you help? Because sometimes we do know the answers and we can take it off the prosecutors because they're in court and they're doing whatever they need to do to focus on the case, and so we don't mind doing that. But if it's like a property, like a business, and the business is the victim, we're not going to be assigned to something like that. So
yeah. And then these are just the misdemeanor cases that we could be assigned to. This isn't all encompassing. These are the main ones we are assigned to. So any person crime that occurs. Again, you see that malicious injury to property. I've been assigned to those cases plenty of times. And a lot of times, you know, the court process, just as you saw, can be confusing. So a lot of times we are assigned to those to keep them updated, especially if you've never been in the criminal justice system before and this is the first time you're going through a court case. It's pretty confusing. So these are just misdemeanor cases that we are assigned to. And then resources. So we touched upon a little bit earlier, but we're really lucky to have Faces of Hope and the Women's and Children's Alliance, also known as the WCA here. Faces of Hope, they do a lot of classes, they do a lot of support groups, and I should mention, any service that you obtain from Faces or the WCA is completely free of charge. They mainly deal with domestic violence, sexual assault, child abuse, harassment, stalking, and elder abuse cases, but they're always open to helping support groups, forensic exams. So if there was a sexual assault, instead of going to a hospital, the victims do have the opportunity to go to Faces of Hope instead. I would say when I get called out to a hospital for a sexual exam, generally it takes 6 to 8 hours from beginning to end, which is quite a bit of time. When we get called out to Faces, it's usually around 4 hours. And I think that's just because hospitals get so busy, everyone's running around, it seems like, when I'm at a hospital. Whereas Faces, it's just you, sometimes a detective, sometimes, well, the nurse will be there, and most of the times a victim witness coordinator will also be there as well. So it just seems a bit quicker, seems a bit more confidential because you're not in a hospital. Again, if you're going to Faces, it's just going to be you, the detective, a nurse, and a victim witness coordinator. So Faces of Hope, it's great that they have that there. U of I Law Clinic, they have that at Faces as well. So they help out with civil protection orders. Say that you have a criminal case pending, there's a warrant issued, but suspect hasn't been arrested. Well, you can always try and obtain a civil protection order. That's where you would go to the courthouse, petition the court on behalf of yourself and or minor children to protect you. It's a little bit different than a criminal no contact order. So the criminal no contact order stems out of that criminal case. If there's no criminal case going, then there wouldn't be a criminal no contact order, which is great why we can obtain civil protection orders. At the U of I Law Clinic, they can help in regards to, you don't need an attorney, but if you're wanting an attorney, that's what the U of I Law Clinic is there for. They can have someone assigned to your case to go with you to those civil protection order hearings. They also offer crisis counseling, so say that you want to start counseling pretty immediately. Faces of Hope generally can get you in pretty quickly. It's more short-term counseling, so say that you go and you want more long-term counseling, we can figure out different counselors. We have lists upon lists of different counselors that are trauma-informed here in Ada County. Again, I think we're really lucky to have the resources that we do have here in Ada County. So if that were an issue, say you finished up your 8 to 10 sessions at Faces of Hope, we could get you more into long-term counseling. They do safety planning there and then emergency assistance as well. The Women's and Children's Alliance, they offer 24-hour hotlines. So if you're having a crisis, don't want to call law enforcement or whatever's going on, they also have hotlines there. They do safety shelters and transitional housing. Usually they have a wait list, but just depending on your situation, if you give them a call, they'll let you know if they can get you in right away or put you on the wait list, which is really great. Their housing is confidential, so I don't even know where the housing is. They do counseling there as well, case management. They have court advocates that go to the civil protection order hearings. So say that you don't have any type of an attorney going with you, but you still want someone there. They actually have court advocates that will go to these hearings just to support you and answer any questions that you might have. They have all different types of classes as well. And then different resources up at the top that you can see are just general resources that we get asked about a lot. So counseling, low-income housing and shelters. We still have really great service and programs that we have for victims here, so we're still able to work with different housing and shelters to make sure that victims, if they need to move, that we can get them into a different housing or shelter situation. Dental, medical, legal, all of those things we are referring victims out to constantly. Safety planning will help with the VINE registration. If anyone's ever curious, you can go online to VINE Idaho, or they actually have an app. So victims can get text messages, emails, or phone calls, whatever they prefer. So if someone bonds out, or if they're moved, say they move, locations, VINE will notify you. And then again, civil protection order and a criminal no contact order. It's talked a lot in the victim witness world. So we just help victims understand if they want to apply for a civil protection order or what their options are for that versus a criminal no contact order. And then emergency hotlines. These are just general resources. I would say I get requests for other resources a lot of the times as well. I've gotten a request for a resource such as, hey, my kids don't have beds, is there any resource for that? And I've actually found a resource for victims that someone will come out, measure, and actually make beds for them. So there's all sorts of resources. Just because they're not listed here doesn't mean that we can't try and locate that resource for the victim. We're always open to, if they have some type, even if they think it's off the wall resource, that's what we're here for. We're here to help them and locate those resources here in Ada County. I think that's about it. Do you guys have any questions?
When you send out a text message to a victim, does it go out in the language that they understand?
That's a really great question.
Is a good question. Go ahead.
So you asked if we text.
When you send out saying that this person's been released from jail?
Oh, the
On the
VINE
Vi-
notification.
That the victim understands?
I don't know how VINE.
That's a great question. In regards to VINE, I would have to contact VINE in regards to that.
Yeah, that's a good. I would think that they would have some, but I don't know. That's a good for us to know.
Yeah. We can get your information and let you know.
Because
Absolutely.
what happens is it's usually a recording. If they don't know what the code is, because what happens, it's usually the last 4 digits of the DR on the police report. And so they may, because they're so overwhelmed as to what just happened, but that VINE will keep calling and calling until you put that code in, and they'll be like, how do I change this? But it's a recording, so I don't know. I mean, I don't know if if the officers or whoever is putting in that, this is the language that they have. But
Yep, because generally if a suspect is arrested, the officers are the ones filling out that paperwork so that the victim is notified of that. But victims also can go on the VINE Idaho site and register themselves. Yeah. Thank you, ma'am.
Have you guys had success finding counseling options for people who are not primarily English speaking? Because like right now I work with the refugee population, and so we have a lot of Dari and Pashto speakers, and it's very difficult to find counselors in the Treasure Valley who speak those languages. So what do you do in those situations?
I have to be honest, I haven't had a lot of yet, and I know it's coming, but as of, I don't know if we just have to make sure that the how that's going to work with the counselor, because there is something to say that there's a loss when you just use the translate. Yeah, so I'm being real honest. Yeah, it's easier to with some of the languages that are becoming more frequent, but that's progressing. That's
Yeah.
What do you do when a crime has been committed, someone has been arrested, but the victim does not want to press charges?
Yeah, that's a great question. If we're called out, we'll still go out to that call, just introduce ourselves, because again, most people don't know what victim witness coordinators are, and it could be as simple as, do you want us to at least notify you of these court dates? We absolutely don't have to. If you don't want contact with us, that's okay as well. But these are the options that you have. We can email you, we can call you for updates. Oh,
do you mean if they don't want charges, right?
They don't want to press charges against.
Right.
But the person has already been arrested.
Right.
Mm-hmm.
We can, it's the state, and that's where we have to try to explain that it's the state against the defendant. And so yes, we have cases where people come in and say, I don't want these charges, nothing ever happened, but then the prosecutor's looking at the police report and there's this evidence that shows, and the state will continue to pursue it. I mean, the name of the charge might change, and we want to hear that from the victim. If they're saying, I don't want charges, then the prosecutor has to think, okay, how do we, this person did break the law, how do we hold them accountable, and what does that look like? But and that's where sometimes we have people that don't talk to us, and to me, that's where it becomes a bigger red flag, because I think, are they getting pressure from their family and friends to get them to drop the charges? And if we don't hear from them, to me, how much more danger are they in? But we get that. But I've seen cases continue to pursue. I've seen cases go to trial, and we still can get a conviction. But
yeah. But the prosecutor will want to know the thoughts and behind that, right? Because no one knows better the context of the history, generally speaking, if there's any type of history between the victim and defendant. No one knows better than that victim of what's been going on. So the prosecutor will want to know, well, what has been going on? Is there any needs that we need to address?
In many of the former refugee communities, usually the neighbors are the ones who call the police.
Right.
And so the police come, but the victim does not want to press charges because of various reasons.
Right.
But a lot of them are cultural.
Yeah.
And so even if this person gets prosecuted, the victim is still afraid, the community is going to lash out against me because, this happened, and so it's going to be my fault, whatever happens, even if it wasn't my fault. So,
I will tell you, those things have happened, and it's hard because the culture is, it's different, right? And so I've had a victim say, I've talked to his family, everything is okay, everybody is forgiven, God says we're supposed to forgive, and just go talk to the judge and say, I don't want this to happen. I'm like, and it's hard, because I'm like, I can't, he broke these rules, and he's got to be held accountable. And I know you feel that way, but I can't just go talk to the judge. I mean, so I totally hear, because that's happened to me, and it's hard it's how we were raised, right? You're raised this way to wrap your head around, oh my God, I don't want this to happen, and it's happening, right? I mean, it would be real difficult.
And that's why the state tries to take it on them as well, that it's the state moving forward with charges. I know that it's not always helpful, right? Right. I know. That is a challenge.
I'm going to interject, because that's what I do. And we've dealt with this a lot, especially in the refugee community. And something that I've learned over the last couple of years that seems to kind of help a little bit, it's not going to completely resolve this issue, but when we start explaining to those who are victims, especially in domestic, the situation where the choice to press charges is taken away from them, or to just dismiss things, is that when they do communicate with the victim witness coordinator and the prosecutor, and they talk about the root cause of the issues, those kind of things can be tied into the punishment. So maybe you have to go to like counseling for alcohol abuse or substance abuse. Maybe you need to go to certain types of counseling that'll kind of address what are the root cause issues that are causing that kind of physical violence in the home. But the courts won't address that in sentencing or probation if they don't know what those things are. So sometimes, even though the victim wants the charges dismissed, okay, that's not an option, we'll explain the system, but they don't understand either that if they actually cooperate with their victim witness coordinator and with the prosecutor, usually they can help make that punishment for that crime that person committed a little more appropriate to make their situation as a family more stable and better in the future. So it's not the perfect solution, but I've kind of started to learn that like actually explaining that to victims, especially in a domestic situation, has started to be a little bit more useful, and encouraging that collaboration and cooperation with the prosecution can actually be helpful instead of just not answering the phone and not showing up and just hoping it disappears and saying it's not their fault.
Right. So we only get a snapshot of what's happened, right? We only have this police report of one incident that's occurred, which is why it's really helpful to understand what's been going on so that, just like she said, root cause, is it alcohol abuse? Maybe is it anger issues? So.
But I worry about that all the time, is that it puts that pressure so much on the victim, and then it's her fault, and the community is blaming her, and it's like, wait a minute, you know, it's, yeah. Oh, there's the one.
Oh, you have the mic.
I just have a quick question for, so let's say you have a victim of domestic violence and the mother, the father, the family, but there's several children and stuff involved with that. Are these services just related to the victim itself, or can they be dispersed among like family members and stuff like that who may also be affected? Because I see a lot of times, like especially in the jail, no contact orders are really hard sometimes to grasp the concept of, especially depending on what the culture is. And so we'll have people that will have a no contact order, but the victim's trying to actively contact the suspect to help arrange stuff, like especially with children who can't see their dad or mom because they don't understand that concept. Then we end up getting them in more trouble because the suspect then contacts the victim. So I don't know if there's like if this service goes out to the entire family or if it's just related to the one victim. But.
Yeah, absolutely. If there's kiddos involved, we'll address that as well. Resources, counseling, things such as that. In regards to the no contact order, if there's kiddos involved, it depends if there was any injury to a child attached to that, or if they were in the home, so domestic violence in the presence of children. Usually they'll be listed on that no contact order, but it doesn't mean that is permanent, right? So a lot of times victims, what we tell them is like, hey, you don't want to violate this. You don't want to get him into more trouble, because if they violate and are convicted of more than 2 violations of a no contact order, it starts to become felony charges. So a lot of times we'll say the no contact order is really a cooling off period. If you want to readdress it, you can always attempt to modify and or terminate. In safety planning that's held at Faces of Hope, actually a judge will sometimes ask, have you been through safety planning? Just to see if the victim, if violence escalates more or again, they have a safety plan to get out of that situation.
And sometimes on that no contact order, we talk about, like at that, on domestic cases, at that 11 o'clock when we're talking to them, we address that no contact order. Were the kids there? Were they not there? Is the defendant, do you feel safe with the defendant having those kids? Because the judges don't like, I mean, there's criminal judges and there's family law judges. They do not like to step on each other's toes. So in my experience, if kids are safe, they have the right to see both parents. So how do we get around the no contact order to allow that? Okay, let's have a third party. Well, your parents or his, those parents, can they do the child exchange? Because it is traumatic on those kids and they still need to see their parent too, if everybody's safe. So there is some of that. And if kids are needing counseling,
they'll start sometimes, sometimes if the kiddo is involved, they'll start out slow saying, okay, well, we still want the mother, dad, whoever was the defendant to see the kiddos. Let's have kids services. Let's have a supervised visitation at the beginning. And then we'll go forward from there. Maybe we can have then, Monday through Friday, you can see them in a public place at a certain time. So there's all types of modifications that you can do for no contact orders that allow visitation in a safe way.
We have a question from the chat. This is from a provider, and they're wondering when they're meeting with clients that could use victim witness services but are scared for whatever reason, what can those providers do to help encourage them and help them see that you're there to help and not to judge?
I've worked with different programs, like the Catch program, and they could have who they're working with call us if they feel that would help them to get that person, or do a conference call with myself and the victim as well as the provider that they're working through. We've done that before too. It's kind of at their field, but or they
and that
answers the question. But.
Both ways as well. So for Faces of Hope or Women's and Children's Alliance, there that goes. If the victim is wanting to get services, but they don't want us to know about it for whatever reason, we will have no idea unless that victim tells us, like, oh, hey, I've been going to counseling at Faces. They have strict confidentiality there, so I always tell victims, like, you can go and seek services, and I never have to know about it. So that kind of goes both ways. Faces, WCA, the Catch program, which is housing, they can always say, hey, we have this victim that's wanting to reach out, can you discuss? So it goes both ways.
Great. Thank you, ladies, very much.